was an assistant DA assigned to that group, and all we did was prosecute DUIs, vehicular assaults, and vehicular homicides. Those of you that want to go into trial law, those of you that want to be in front of a jury in a courtroom, there's no better place to start out than the prosecutor's office. You get thrown into the fire from day one. And that is where, I guess, began the experience, and obviously have been out now for about a year and a half in private practice. The majority of my practice is criminal, and the majority of that criminal practice is DUI law. So, like I said, it's a fun area of the law, it's an interesting area of the law, and there's probably more case law that goes into a DUI than just about any other crime you can think about committing, especially in Tennessee. Tennessee takes its DUIs very seriously. The penalties are very harsh, more so than most other states. I'm sure, as most of you know, the legal limit here is .08, and getting a DUI dismissed or reduced is very difficult to do in Tennessee. Like I said, they take it very, very seriously. As far as driving under the influence, I know we've probably got first year, second year, third year students, all the above in here, but you don't have to be a law student to know that in any criminal prosecution, the state's got the burden of proof, and they have to prove beyond a reasonable doubt that the person charged is in fact guilty of what they've been charged with. The three elements of driving under the influence are that someone was driving or in physical control of an automobile on a public roadway or street while under the influence, and it's really that simple. As far as the first element goes, there's a couple of things that most people don't realize, but the law, like I said, it states that the first prong of the first element of what has to be proven is that somebody was driving or in physical control of an automobile. Typically, that's the least contested element of a crime, of this particular crime, but what comes into what can cause some interesting motions here and some things like that is the physical control aspect of the law. There is the seminal case in Tennessee is a case called State v. Butler, and believe it or not, it's out of Madison County, which is Jackson, Tennessee, and there was a guy that was in a Walmart and was doing his shopping, whatever he was doing in Walmart. He had a motorcycle that he drove there that was parked about 100 yards away from the entrance of the Walmart. He goes in, he does his shopping, and apparently, while he was walking in, somebody had called the police saying that they had witnessed somebody staggering into a Walmart and looked to be under the influence of something. He walks out of the Walmart, still about 100 yards away from his motorcycle, and he's stopped by a police officer. He's got the telltale signs of driving under the influence, odor of alcohol, slurred speech, unsteady walk, bloodshot, watery eyes, which I'm convinced that if you wake a police officer up out of dead sleep, that's what they're going to wake up saying. Bloodshot, watery eyes, slurred speech, odor of alcohol. So any DUI you come across, you're going to see that. But the fact that he had the keys in his pocket and his motorcycle was 100 yards away from the entrance of Walmart where he was stopped, he was charged with and convicted of driving under the influence. So those of you, I have clients all the time that come in and say, well, it was the middle of January, I was at a bar, I walked outside, realized I was too drunk to drive, was doing the right thing, was cold as hell, so I got in my car, started up, turned the heat on, and passed out. And then 10 minutes later, you hear this police officer knocking on the window. That person will be charged with and likely convicted of driving under the influence. So the next time you're at a bar and you think you're doing the right thing by sitting in your car and turning on the heat, don't. And call a buddy, take a cab, do what you got to do. Because like I said, if you are even standing outside of your car with the keys in your pocket, if you can potentially foreseeably make that car, motorcycle, truck, whatever, run, and you be the operator, you can be at least guilty of that first element of driving under the influence. The second element, on a public roadway, obviously it's not rocket science. It's obviously the second least litigated element of driving under the influence. And the legislature has gone to great lengths to make sure that there's no misunderstanding about that. The law actually reads, the only time you're going to have an issue with whether or not somebody's acting on a public roadway or street, every now and again will come from an issue where somebody's in a private parking garage, or they got an apartment complex that's gated and has security out front. Blair actually lives over by McCabe's golf course, and has asked me numerous times that if he got a golf cart and wanted to drive to and from McCabe with his little son, could he get stopped and arrested for driving a vehicle? And he absolutely can't.
Not with my son. Not with my son at that point.
I'll send that $10,000 minutes. But yeah, boats, bicycles, golf carts, the state can make anything that they want of a vehicle. So then obviously the third element is on the influence, and that's where most of the litigation on any DUI occurs, whether or not somebody's actually under the influence. It could be obviously the influence of alcohol or any stimulating, producing effect. There's actually in Tennessee there's two ways that you could be convicted or at least charged driving under the influence. Does anybody have any idea what I mean by that? Well, Tennessee is I don't know. Some of you may have heard of the implied consent law. The implied consent law basically says, and what most people understand is that the minute you get your driver's license in Tennessee, or even those of you that are coming here to Vanderbilt from out of state, if you've got an out-of-state license, the minute you drive on roadways in Tennessee, you are deemed to have given consent for your breath or blood if you're ever unsuspicious of driving under the influence. So there's what's called the implied consent law. Anytime somebody's not driving under the influence and you go to the field sobriety test and the police officer believes they've got probable cause to arrest you, they're going to ask you to submit to the breath or blood test. Here in Davidson County, they're going to ask you for arrest out there ever offer blood. Tennessee's not one of the states that's going to direct you down to a crane and stick a needle in your vein and take your blood against your consent. It actually falls under the Fourth Amendment certain season. So in order to supply the government with a breath sample or a blood sample, you have to give consent for them to do it. But you, like I said, you have the opportunity to refuse any one of those. Should you be in that position where you refuse a breath or blood sample, you will be charged with violation of the implied consent law. The implied consent law is actually not even a criminal charge. It loses your license for a year. So that's where the two ways you can be charged with and convicted of DUI and come into play. You can be charged with and convicted of it without a breath test or a blood test, violating the implied consent law. Or you can be charged with what's called per se, which means you submitted to a breath test or a blood test, and the result of that breath or blood test is over 0.08 legal limit. I can tell you that I've tried, I don't know how many cases with and without breath test or without blood test, and gotten convicted as prosecutor on just as many implied consent cases as those without or blood tests. So, you know, it never ceases to amaze me. People come in and I got clients who come in and say, well, I was stopped for doing 102 and 35, and if you're drinking all afternoon, and officer asked me to get out of the car, you try to tasks, and then he asked me for a breath or blood test, and I said no, because I wasn't going to give him that proof. Well, you know, a lot of times they don't need that proof. So, and I know some of the questions you guys probably not asking, we'll get to all that shortly. But in terms of what you've asked me to talk about today, and I know that this is somewhat of a constitutional law. There's a whole lot of constitutional law goes into driving under the influence, and like I said, it's probably one of the heaviest litigated issues from a criminal standpoint in Tennessee. There's every aspect of the law from Fourth Amendment search and seizure to Fifth Amendment, Miranda warnings, Sixth Amendment right to counsel, to consent, credibility of the officer, reasonable suspicion to stop, probable cause to arrest. A driving under the influence charge will run the gamut of constitutional law from beginning to end. But from a defense standpoint, that's where I typically will evaluate a case from beginning to end, the absolute minute person gets in the car, to the time they got stopped. Was there reasonable suspicion to stop somebody? Obviously, usually, most DUIs occur not when people have wrecks or not when people run over somebody. It's when people are driving up the speed limit, or they're driving without their headlights on, they're swerving in and out of the lanes. And it's usually what are oftentimes considered minor traffic things that will get you stopped in the first place. The goal in any DUI defense to obviously keep the DUI somehow or another off your record, and there's a couple ways to do that. But in terms of getting something suppressed, the best way obviously is to find something that's early in the investigation that you can hang your hat on, sink your teeth into, and file a motion to suppress. Is there a best stop? Is there no reasonable suspicion to stop somebody to begin with? If you can establish that, and that's obviously one of the best ways to go about it. Everything beyond that point is something you guys already know. So the earlier case you can find something that's maybe unconstitutional and improperly, hang your hat on that, and like I said, get things beyond that.